Hey, Jeff. Thanks for joining us today.
Glad to be with you, Dave.
So, the topic today is past presidents. My first question to you is what, if any, fiduciary duties are owed to a society or an association by past presidents who are no longer on the board?
So, if a past president of an association is no longer on the board and they're no longer an officer, then they do not owe any fiduciary duties to the association. Fiduciary duties are owed by officers, directors, which means board members, and senior staff. Those are the three categories of individuals that owe fiduciary duties. Past presidents do not owe any fiduciary duties to the organization.
So, in essence, then they almost revert to regular members who are free to share their opinion like anyone else. Is that right?
So from a purely legal fiduciary duty perspective, yes, they're no different than any other member if it's a professional society or representative of a member if it's a trade association. But the practical reality is that's not the case because they are past presidents. They're viewed as being, former senior leaders of the organization. In many associations, they are kind of first among equals. They're not just like every other member or former board member, especially as a past president, as opposed to just saying a past board member. They occupy a unique position of respect and stature within many associations. And so their voices are louder and carry more weight. And that's potentially problematic because they may be viewed that way, by the rest of the membership, by the industry or profession. But from a legal perspective, they don't occupy the same position.
Yeah. So, fiduciary duty, no, but they do have unique responsibilities that they have to take very seriously.
They have unique respect and a louder voice that, yes, they need to understand and be very respectful and mindful of. And there's something else. There's this doctrine in association law called apparent authority. Came from a 1982 U.S. Supreme Court decision involving the American Society of Mechanical Engineers. But what it basically says is that if someone, like a representative, a case obviously involved in association, if a representative of an association has the apparent authority, if it's reasonably apparent to third parties that that person has some authority on behalf of the organization, even if they do not in fact have such authority, then what they do can actually bind the association. So if they're acting on behalf of the association and they take an action, or even worse, like signing a contract or something like that, and it's reasonably apparent to that third party that they do have that authority, the association can actually be held liable for their acts or omissions. And so even from a purely legal perspective, that's another reason to be very mindful of the position they occupy.
Thank you. Great advice. We often talk about onboarding programs with our board. Do you recommend having an offboarding program, if you will, for past board members and maybe specifically past presidents?
Yeah, it's a great question. It's a great suggestion, something I firmly my colleagues and I at our firm firmly believe in. Unfortunately, it's not something that we see happen very often at all. You're right. Great onboarding. I get involved in onboarding for a lot of our clients, doing board legal trainings for once a year for the board, including new board members and that sort of thing. And most associations do a great job onboarding their board members, but not offboarding. And you're exactly right. There are things like, one of the things I always stress in board trainings is the critical importance of the duty of confidentiality, which is part of the fiduciary duty of loyalty that board members owe to the organization, including past presidents. And that duty extends once they leave. They no longer owe the fiduciary duties, but they're bound because of those prior duties to keep anything that's confidential that they learned through their board service, the president's service, confidential. But things like either returning or destroying. In these days, virtually everything's electronic, though it's more about destroying than returning, board books and other confidential documents, perhaps even confidential emails, making sure they understand expectations about maintaining confidentiality, even verbally, with respect to things that they learned. And other things like that, in terms of what we were just talking about a few minutes ago, in terms of not using that unique role and perch that they have as a past president and speaking out, creating issues of apparent authority or things like that. I think a strong offboarding program is a great idea, but I actually see very few associations, including our clients, even doing that.
Yeah, honestly, we don't see it very often either, and we strongly recommend it as well. So my final question for you is, what do you think is the best role for past presidents? So often we see, for example, past presidents, councils, we have a formal role in governance, some of which don't. What do you think is the ideal role of past presidents in governance?
Well, I'll start with saying what I think is not is the opposite of a best practice. A really bad practice is for bad, in my opinion. So obviously my personal opinion, but based on 26 years of deep experience representing hundreds and hundreds or thousands of associations, including in the governance area. And I've seen it once in a while where past presidents have a formal role in governance. You know, I've had some clients, I've strongly counseled them against it. Most of them made changes where past presidents are invited to every future board meeting. And even their expenses paid by the association to come to those board meetings. And and I've been at some of those board meetings where they speak up. And again, because they're past presidents, even though they're not currently on the board, well, that raises a whole host of other issues. Whenever you have non-board members present at board meetings, it poses all sorts of privilege issues, attorney-client privilege, qualified privilege, confidentiality issues, other things like that. But that aside, even when they speak up, their voices carry undue weight because they're viewed as being kind of the senior leaders, the former senior leaders, and they're experts, and therefore their voices tend to be louder than, say, a new board member on the board. I think that's a terrible idea. Always counseled against it. I had one client that actually just last month, I was at the membership meeting where the vote occurred to amend the bylaws, and one of the things that the association's board recommended and the membership approved in the bylaws was that they had their past presidents essentially serve as the nominating committee to nominate all future board members. And what ended up happening over time is that it got viewed as kind of the old boys club, and it actually was mostly men, virtually all men. That's changing, thankfully, with that association. But it was literally the old boys club, and it was tough for people to get into the leadership track because all the nominations were coming just from the past presidents of the organization. They did away with that, and they installed, a more modern day best practice type nominating committee that it might have one or two past presidents on it, but not by design. And the idea being you want to get a diverse group of folks, that really is going to have the best pulse on what the future boards of the organization should look like. So in short, I am strongly opposed to any kind of formal role for past presidents in board governance. What I do see on occasion, and I have not seen any real problems with it, is having like past presidents have some kind of advisory council, that say meets once or twice a year, either in person, virtually, not suggesting that the association pay for travel expenses for that sort of thing. But, maybe have a once or twice a year meeting virtually, kind of a part out of respect for the past presidents, certainly appreciating all of their hard work and service, because it is a lot of hard work and deeply appreciated service. Having the CEO, maybe the current chair, president, whatever the title is, update them on what's going on and ask for their general feedback. Maybe you have the executive committee members on that call as well, so they can listen to the feedback and maybe incorporate it, maybe take it to the board of directors, not where they have a formal role to be able to propose board resolutions or things like that, but just to provide general feedback. I don't think that's a bad idea at all. I think it can be very helpful because they do have a lot of knowledge and experience to contribute, but frankly, and of course, being ambassadors to the membership and whatnot is fine, again, as long as they're mindful of the fact of this apparent authority doctrine and that they're not speaking on behalf of the association. Even there, I think you have to be careful. And I see it often where they get invited, like, the annual membership meeting or annual board meeting, if they want to, on their own dime, come to the meeting and you have some reception, board reception the first night or at the end of the board meeting, and, you invite them to attend the reception. I think that's a really nice gesture. I've seen that a lot. That tends to work well. But frankly, anything more than that can be very dangerous from a legal and a governance perspective, and frankly, not particularly healthy.
Well, great, Jeff. That's terrific advice. Thanks so much for sharing that with us today.
You're very welcome. Glad to be here.